Mr. Chief Justice, thank you so much for giving us your time. It really is an honor to visit with His Honor.
Well, thank you.
What exactly are you right now asking people to do, and why?
Well, right now we're not asking anybody to do anything. We're engaged in a conflict with the federal court, and the Supreme Court of the United States has just issued a horrendous opinion that I think contradicts the Constitution. So we're fighting with briefs, and we're fighting and writing and speaking and letting people know what this is really about.
Justice Scalia, in his dissent, and he's no dummy, he uses words with incredible precision. He called this a judicial pooch.
Yeah. Yes, basically, just like he refers that to the Nazi Germany time period, and basically it's a seizure of power by the judiciary over and above the Constitution ever imagined. In fact, this is really adverse to our religious liberty. It's adverse to the Constitution and has no basis in the Constitution. One of my favorite quotes in there was what Justice Roberts said when he said that if you're on the other side, that you may have a right to celebrate and you may have a right to do this or that, but don't celebrate the Constitution because it had nothing to do with it. And I think the four dissenters in this case clearly showed that the Constitution had nothing to do with it. In fact, Justice Roberts says, who do we think we are? And I think that's a good statement. Who do they think they are when 5 lawyers, and that was a reference to Justice Roberts, said 5 lawyers have closed the debate, enacted their own vision of marriage as a matter of constitutional law. And I think that sums it up.
He said something in his dissent that I felt was pretty ominous, and I'll read to you a couple of things. He said, Dred Scott's holding, the slavery decision, Dred Scott's holding was overruled on the battlefields of the Civil War. And then he went on to say those who founded...
constitutional amendment.
Right. And then he said, they, after all, about our founders, he said, they, after all, risked their lives and fortunes for the precious right to govern themselves, and they could not have imagined yielding this to unelected, unaccountable judges.
I think one of the things I noticed in the dissent is all 4 dissenters kept referring to 5 lawyers or a committee of 9, talking about the whole court, but they were very disparaging as to exactly what these people on the other side had done. The majority opinion in this case certainly was an act of will, not of law. It was an act of that should have been left to the legislature. In fact, I think it was Justice Roberts cited that you'll notice there's nothing in there about the normal state authority over marriage, which they cited in 2013 in U.S. versus Windsor. And this same justice, Justice Kennedy, wrote in Windsor that these matters had historically been left to the states under the Constitution of the United States. And they were not matters for the federal government. That's exactly what they said when they overturned DOMA, the 1996 law regarding marriage between man and woman.
Justice Alito, as you know, I've already heard you and seen you quoting from him. He said that in so many words, that this was going to pave the way for persecution. That this new orthodoxy, that people are going to end up in court from stuff that they happen in their jobs or perhaps.
He said it would vilify Americans.
Yes,
who are unwilling to assent to the new orthodoxy.
They'll whisper things, but they'll be afraid.
Said, sometimes you may be able to whisper in your homes, and that's basically what they've reduced religious liberty to. They're saying that you can teach and advocate, but you better not do anything. Well, you know what they used was a reference to the First Amendment, but they left out one word, and that's exercise.
Right.
The free exercise of religion. And when you forget that your faith is more than about just what you talk about, it's where you are. And that's what this court is really going after, what you do.
I can see people hauled into court for civil lawsuits.
They will be.
Over businesses. I can see people going to jail for contempt of court, because if a judge says to a man, do this, and he says, I'm not doing it.
Well, it's a violation of your religious liberty. Thomas Jefferson.
Can you see people
certainly
being sued or going to jail over contempt of court?
Sure. And, you know, back in the 1700s, people went to jail because they did not follow the faith of another church or something. The Baptists were persecuted. and
So
in
were the
Virginia,
Catholics.
and so were Catholics. But basically, that's what's going to happen in our time. Thomas Jefferson, who authored the Bill for Religious Freedom, said something that's very appropriate for this day and time. He said that to suffer or allow the civil magistrate to intrude his powers into the field of opinion and restrain the profession or propagation of principles on supposition of their ill tendency is a dangerous fallacy, which at once destroys our religious liberty, because he, talking about the civil magistrate, being judge of that opinion or that tendency, will make his own opinion the rule of judgment and approve or condemn the sentiments of others only as they square with or differ from his own, that it is time enough for the rightful purposes of civil government for its officers to interfere when principles break out into overt acts against peace and good order. Now, certainly if you apply that to this case, the principles of peace and good order have not been breaking out when you're talking about marriages between a man and a woman. That's existed for centuries, even thousands of years.
Right.
And that's before
Even
the
the
United States Constitution
Even the
began.
pagan Greeks and the
That's
pagan
right.
Romans who had
And
homosexuality and had pedophilia, they did not stoop to this.
Yeah, to say that it's time enough for the rightful purposes of civil government when principles break out and overt acts against peace and good order. There's been no breakout peace and good order by marriage between a man and woman. And it also says that the magistrate would set himself up to make his opinion the rule of judgment and approve or condemn the sentiments of others only as they square with or differ from his own.
Alito said basically what this, I'm paraphrasing, but he said basically what this court has said is we're going to do what we want on any matter until somebody in the political or social sphere has the guts, the backbone to stand up and push back.
If we don't stand up now, we won't be able to stand up, because what this court has done in this case is basically remove religious liberty by mandating that people who disagree with same-sex marriage must issue licenses,
Oh, right. You're gonna,
must provide flowers. Now, they didn't say that, but they
of course,
indicated,
right.
and the federal courts have been mandating this across the country.
Yep.
We had in Washington a lady with a flower shop
Yep.
that didn't want to display flowers for
Didn't want to sell
same-sex
flowers.
wedding,
Mhm.
and she was sued.
Yes.
We have a bakery, and we have
The pizza parlor was...
the pizza parlor, and a SEAL chaplain that lost his job because he counseled soldiers or sailors under him
to not go
about
into that
homosexuality
lifestyle.
lifestyle. Yes, and it's just it's a persecution that's just beginning. It's going to touch the American people when
Well-
you're forced to accept evil, something that historically did not exist, same-sex marriage, and to condone sodomy, which this same Justice Kennedy ruled okay in 2003,
Right.
then it's against their faith. And it's naturally going to be hard to take.
I'm going to come back to something that I alluded to earlier. I could be wrong, and you could say if you think I'm wrong, but when I read the four dissents, with the exception of Thomas, his allusion was a little lighter, but all three of the others made allusions or alluded to the possibility for violence. They kept referring to the Civil War, the Revolutionary War, that people fought for no taxation without representation. Scalia said that. He said, look, these people fought for no taxation without representation, but this is more important. No social engineering without representation. Do you think, and this is conjecture on my part, but do you think that this decision is going to lead to things that we don't even want to think about?
Well, I can't predict the future. I don't know. I do know that Justice Thomas said that numerous amici, or those that submit briefs, have cautioned the court that its decision here will have unavoidable and wide-range implications for religious liberty. It appears all but inevitable that the two will come into conflict. The majority appears unmoved by that inevitability. In other words, I don't think the court cares what happens. The court has just issued an order, and you're referring to Dred Scott, and that was the ruling in 1857 where the Supreme Court said that black people were property.
Right.
And I think Justice Roberts said that was overcome on the battlefields of the Civil War and by constitutional amendment.
With a gun to the head of the Confederate States.
What he was saying is that it took that much to overturn that decision.
Yep.
I hope we don't have a war. I hope we don't have conflicts. But we definitely need to recognize that same-sex marriage is something that has not existed at a state level or government level.
There's so many things I want to touch on, but I am of the opinion that if Thomas Jefferson and George Washington and Patrick Henry, if they were here today,
they would be incensed.
Well, they would not only be incensed, but they started a war over taxation. I mean, this is like, we're going to make the colonies into Sodom and Gomorrah. I don't think so. I don't think that they would have tolerated
I think
this.
there's going to be a great backlash to it, and I think people have not seen what the consequences of this court's ruling are yet, and we'll wait and see what they do.
Justice Thomas was the only justice to refer to God.
He referred to the law of nature and the law of God.
Yeah, and the Creator, and he quoted how John Locke wove in the concepts of rights coming from our Maker. With his dissent as the exception, this was actually a godless decision.
What shocked me the most is knowing that when they went on oral argument, no one mentioned the basic reason we have marriage. It's because God ordained marriage as between a man and a woman when he created woman from the rib of Adam. And nobody even mentions that, despite the fact that the United States Supreme Court did in the 1800s. Yes, they said in Murphy versus Ramsey, they said that family springs from the union for life of one man and one woman in the holy estate of matrimony, the foundation that is most stable and noble, the best guarantee of that reverent morality which is a source of beneficent progress in all political and social improvement. They're saying basically everything that society is based on is the family, and that's started with a man and a woman.
Right.
And naturally, by nature, it starts with a man and a woman to produce children. I appreciate Justice Thomas mentioning the law of nature and the law of God. Those are legal terms in those days that we have lost any concept of.
Right.
The law of nature and the law of God. Blackstone wrote, it said, upon these two foundations, the law of nature and the law of revelation, depend all human laws. That is to say, no human laws should be suffered to contradict these. And
allowed, Old English, should not be. No human law should be allowed that contradicts the laws of God.
Right.
Yep. So this is an affront to heaven. I mean, there are 4 sins that cry out to God: shedding innocent blood, Sodom and Gomorrah, sodomy, abusing orphans and widows, and slavery, withholding a man's wages, which is slavery. So slavery was settled with horrific bloodshed. Abraham Lincoln said in his second inaugural address, in so many words, that this was the judgment of God. Mm-hmm. Could it be that every drop of blood that was drawn by the master's whip is going to be shed on the field of battle? I am afraid, for the first time in my life, I'm actually afraid for the future of our country, because I feel like we've crossed some Rubicon. Something's going to happen, because there is a God in heaven. Even if the judges want to pretend he's not there, there is a God in heaven, and he hasn't rescinded his authority.
And not only are you refuting the institution God first ordained, but you're undermining the very foundation upon which all our society is built. It must be built on something. It's built on family. And when you take away the meaning of family, and that's what they've done. They haven't redefined family.
By God. That's the issue. Is that, in other words, before family was God himself. So the traditional values argument, I think, is very dangerous for Christians to take the bait, because the question is, whose tradition? I mean, Sodom and Gomorrah had a tradition. So it's that God gave us family.
Yeah.
And
well, I think that's something that they didn't recognize in this opinion. And they recognized that we were evolving as in the word marriage. They destroyed the definition of marriage. They haven't really given us one. Their reasoning would apply equally well to polygamous marriages.
Yep. One of the justices said that.
And one of the justices basically said that.
Yep.
So,
what role do you believe that God plays in the body politic, in civil government?
Well, I think he had a hand in our Constitution, according to Madison, according to nearly every one of the founding fathers, that he looks over our society. He's not some God that doesn't take an interest. And, you know, when we cry out to him, and he answers our prayers. I think one of the best quotes about that was back in 1863. And it said, whereas one of the proclamations of the president back then was, whereas it is the duty of nations as well as of men to own their dependence on the overruling power of God, confess their sins and transgressions in humble sorrow, yet with assured hope that genuine repentance will lead to mercy and pardon. And it goes on and it says basically...
Those are preaching words.
It says, have we now forgotten that powerful friend? We've been the recipient of the choicest bounties of heaven. We've been preserved these many years in peace and prosperity. We've grown in numbers, wealth, and power as no other nation has ever grown, but we've forgotten God. And that was in 1863.
What role do you think the laws of God play in the body politic?
Well, the laws of God are, you know, the Ten Commandments basically are underlying our foundation of moral society. They illustrate religious freedom. Back in the dictionary in 1838, I believe it was, 1828, Webster's dictionary, it was defined as the religion and morality were the first and second tables of the law, referring to the Ten Commandments. Right. Washington said in his farewell address, of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. He was referring basically to the law of God.
Right. Christian morality.
The first table being the duties we owe to God, and the second being the duties we owe to each other, our virtue, our morality. Today, we've
when you say table, you mean also tablet. In other words, there's two tablets to the law. The first rules, or the first laws.
They call them tables of the law.
Right.
And they also call them tablets.
Right. For the viewer who's...
Sure.
I love your use and addiction to Old English.
Well, it's just...
But we can't suffer the words to confuse the viewer.
Yeah, I understand.
Do you believe that the judges violated their oath of office?
They're sworn to the Constitution. The Constitution has no word in it about marriage, and that's remarkable. If they're going to redefine a word that's not even in the Constitution, how is that not a violation of the 10th Amendment, which states clearly that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. There's no power given to the federal government, as Justice Kennedy in his own writing in 2013 in U.S. versus Windsor recognized. There is no power given to the federal government over marriage. That was left to the states. And today that's been taken, and a majority has dictated that to the states.
Okay, there's so many politicians right now who are saying that this is outside of the rule of law, that they went beyond their constitutional authority. So we hear all these words, but then if that is the case, is this an impeachable offense?
Well, 4 justices on the Supreme Court, that being Chief Justice Roberts, Justice Scalia, Justice Thomas, and Justice Alito, all said that about the opinion.
Right, that this is basically a lawless.
It was completely outside the Constitution. And basically, even the majority opinion didn't reference the Constitution that much. It represents how they felt about things.
The 5th and 14th Amendment, a really bizarre, twisted...
Well, what about the 5th and 14th Amendment that is strange is back in 1986, the United States Supreme Court, in the case of Bowers versus Hardwick, addressed what the court did here today.
Which said, Bowers versus Hardwick said that the rules against that behavior were constitutional.
They said there's no constitutional right to commit sodomy in the Constitution in 1986. They said, nor are we inclined to take a more expansive view of our authority to discover new fundamental rights embedded in the due process clause. The court is most vulnerable and comes nearest to illegitimacy when it deals with judge-made constitutional law having little or no cognizable roots in the language or the design of the Constitution. That's exactly what it is.
Say that in the vernacular of the common folk.
It says when the court is illegitimate, when judges start making constitutional law which has nothing to do with the Constitution.
There you go.
And using words that are not in the Constitution. It then went on to say Therefore, there should be great resistance to expand the substantive reach of the Fifth and 14th Amendment, particularly if it requires redefining a category of rights deemed to be fundamental. Then listen to these words. Otherwise, the judiciary necessarily takes to itself further authority to govern the country without express constitutional authority.
They're usurping power to themselves, making themselves
and
tyrants.
they're governing the country without authority to do so.
So, again, I ask, in your opinion, and I'm inviting you onto thin ice, perhaps, but do you think that they have committed an impeachable offense?
I think they can be impeached. Now, there's two ways to impeach, in my opinion.
Okay.
One is the fact that they've just exceeded their authority under the Constitution. And here's the clauses under the Constitution. Article 2, Section 4 says, shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. The other way, under Article 3, is that in such inferior courts, and the judges both of the Supreme and inferior courts shall hold their office during good behavior. And it's questionable whether this is good behavior, and I would say a reason for that. Justice Ginsburg and Justice Kagan both had performed same-sex marriages. And under 28 U.S.C. 455, it requires their recusal when impartiality, quote, may reasonably be questioned. Now, if you're out performing same-sex marriages and then go into a case to determine whether that's legal, and you say, under the Constitution of the United States, I think that's when your impartiality may reasonably be questioned. Right. They were both notified of this by briefs and by requests for their recusal from the Foundation for Moral Law, even before they heard oral argument.
Well, they didn't
recuse.
So under those two principles, either one of those, well, they could be impeached. I don't think that the political will exists.
No.
But I think that it's a point of law that we need to not let go of personally.
Well, the point I was trying to make is Congress has made rules for recusal. And all the good judges across the country are under rules like that, whether state or federal. They knew the rules. They knew there's nobody over them and that Congress is not going to do anything. And they sat on this case, two justices that had performed same-sex marriages.
They're clearly biased.
Justice Ginsburg performed a same-sex marriage after a notice of recusal was filed in the court on April 27th. It was not noted on the dockets until May 21st, and I'd say it was not noted on dockets till after June, actually. And she performed another same-sex marriage, and
they don't care. There's a brazen arrogance there that's breathtaking. And the lack of political courage and will from people like McConnell, Boehner, the people who play to us with their words. We're for marriage, we're for pro-life, blah, blah, blah. But then when really comes time to stand up and to fight, they don't do it, they roll over.
You know, 1986 in Bowers versus Hardwick, that was the case that was brought to the Supreme Court from Georgia in the first test of sodomy. And the Supreme Court found there was no right to commit sodomy under the Constitution. In that case, argued by Lawrence Tribe, who lost, it went down in history as declaring that sodomy was not a right. 17 years later, another justice by the name of Anthony Kennedy found such a right and declared that that was not proper law. What you should know is it was Lawrence Tribe who spoke for Anthony Kennedy to become a member of the bench. And they talked about these specific issues. And this is something that was out on...
They ignored the law, precedent, stare decisis. They want to use it when it's to their benefit.
They set up their own future there.
Let's take a radical turn towards history. In Nuremberg, the underlying principle of Nuremberg was that crimes committed under the color of law cannot be protected.
No, because they were a violation of the higher law.
Right. I mean, the victorious Allies wrestled with this and said, look, we can't allow what they did to go unpunished.
Well, Justice Jackson, who was the United States Supreme Court Justice, is one of the prosecutors, actually. He came off the bench to be a prosecutor at Nuremberg, and he basically declared that you can't get by with murder by saying the state or the Hitler told me to do it. And they say for that you could be prosecuted. And yet today we're not looking to those same laws.
I think some of the most damning words of all of human history are, "I was just following orders."
Well, that's exactly what Lieutenant Calley said in Vietnam in the 1960s. And he said that orders were from Captain Medina, his superior officer. The court-martial said it doesn't matter who gives you orders. If it violates the Constitution, it's against the law. And this is certainly like that today in our court system.
What should governors, state attorneys general, state attorneys general be doing right now?
Well, just like Roberts implied, the efficacy of the judgments of the high court are in the hands of the executive and the states. I think the states should be addressing these issues as they see fit, instead of just taking a hands off and saying, well, it's the law of the land.
Right,
that is a great misunderstanding. The law of the land is, always has been, always will continue to be the United States Constitution and the laws of the United States made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States. That's what's stated as the law of the land. That's in Article 6, right here. It says, this Constitution and the laws of the United States made in pursuance thereof, and all treaties made or which shall be made, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or the laws of any state, to the contrary notwithstanding, which means state judges have a very immediate and proper role to play under the Constitution of the United States. It's not just the Constitution of the state they're under the Constitution of the United States, and they must know and interpret that Constitution. And that's one thing we brought up in Alabama when the federal...
If I may, let's come back to what governors should do, or what could they do. In other words, address it from a constitutional argument. I'm the governor of Arizona, I'm the governor of Louisiana, and I say, this decision, I say to
if
the court,
it
I'm
doesn't
not
follow
gonna
the Constitution, then their duty is to interpret the Constitution. That's what they're sworn to do.
You're my lawyer. Let's pretend that you're my lawyer. Some young lawyer is going to, or an old lawyer, a seasoned lawyer is going to advise me. I'm a governor of a state, and I'm saying this decision is from hell, literally from hell, and I'm going to tell the justices, take it back to hell where it came from.
If a decision contradicts the Constitution, it's not law. And if it's not law, then you're not to obey it, if it's contrary to the United States Constitution. Now, many people believe, wrongfully, I might add, that just because the United States, just because one man, Justice Anthony Kennedy, decides for the majority and writes the opinion, as he done in Bowers versus Hardwick in 1986, or I'm sorry,
No,
2003, right. Lawrence v. Texas,
right.
And then in Windsor in 2013, and now in this case, Oberfeld. Just because he writes it doesn't make it
law
if it contradicts the Constitution. Now, some people are going to say, Chief Justice, you're just a state judge, and you're saying it contradicts the Constitution. I'm quoting Justice Alito, Thomas, Scalia, and Roberts. And they all say it does not
has nothing to do with the Constitution.
With the Constitution. Justice Roberts says it had nothing to do with the Constitution. So I'm not saying this on my own. I'm saying this from the four senators. Listen to this. Justice Thomas, the court's decision today is at odds not only with the Constitution, but with the principles on which our nation was built. Supreme Court, Justice Scalia said the Supreme Court of the United States has descended from the disciplined reasoning of John Marshall and Joseph Story to the mystical aphorisms of a fortune cookie. I mean, their criticism of the minority was much more severe than I can even quote.
Scalia putting the bag over his head. That was actually funny.
Justice Thomas said the distortion of our Constitution not only ignores the text It inverts the relationship between the individual and the state in our republic. Today's decision shows, according to Justice Alito, that decades of attempts to restrain the court's abuse of its authority have failed. Now,
if you were a governor, I want you to say the words that you would say when you stood up in front of the microphone, when you called the press conference and said, I am not going to, as the governor of this state who swore an
I'm
oath,
going to follow the Constitution, and the Constitution doesn't tell the states how they should regulate marriage.
So, Mr.
Because
Governor,
marriage is defined as one man and woman, has been, is defined by the Constitution of Alabama. And
so, Mr. Governor, are you saying that you are not going to tell your various county officials to issue marriage licenses?
that's what, in fact, that's what the Texas governor is basically saying. If it violates their religious liberty, they're not to issue them.
But the ones who say, I believe in this, they're going to still issue them. So the point is where,
well, if you
where
got a
does judge-
constitutional, it depends on what your constitution, state constitution says. In our state constitution in Alabama, 81% adopted it and said that it is between one man, one woman. That's the law of the state.
So could conceivably, and could a governor be within the law?
Yes.
And
Well,
say,
governors,
we're instructing all of our officials, you are
defines
to not issue these. We will not honor this decision. We will not abide by it.
and again, when you say within the law, that means what law? And the only law we have is the United States Constitution. The opinion of justice is applied. If it's outside that Constitution, it's not law.
I agree completely. I'll be honest with you. There's people that are watching you right now and listening to you, and their insides are churning because they're watching their country die.
Well,
And they're looking for people to be heroes. They're looking for people to be leaders, to lead us out of this mess, and to stand up to these people. So, what words do those leaders use? What passion must burn in their soul? What's their guiding light?
well, it varies from state to state. Some governors have just said, well, I'm going to follow the law. And they refer to the justice's opinion. And many say, well, that's now the law of the land. And I keep reminding reporters and people that ask me that the law of the land is not the opinion of a court. Courts don't make law. We all learned that in, schools. Courts don't make laws. Who makes laws? Congress and legislatures. So it's not a law Congress made. The legislature makes laws, and then we have the constitutional amendments, which are laws. And if there's no word about marriage in it, then how do they invent the word to mean something it's never meant?
Well, let's say that
Then they find fundamental rights that are not in the Constitution. The fundamental rights, by their own history, is something that's in the long history and tradition of a nation. Same-sex marriage is not in the long history and tradition of a nation. So it can't be a fundamental right.
Right.
It's a fundamental right because marriage between a man and woman is a fundamental right because it was there to procreate and to educate and maintenance of children.
the first church. What do you think would happen if one governor in this union said, we're not doing it. We're not going to issue licenses. We will not honor licenses from another state. This is a tyrannical ruling. It's completely outside the rule of law, and we're not going to abide by
And we
it.
would certainly call into question this United States Supreme Court ruling, and people would start looking at it pretty well. And it would also be an interposition between the people and a higher authority. And this has happened throughout our history. In fact, it's the reason we're here as a nation.
As Americans.
Because 56 men in the Declaration of Independence interposed. They were representatives of the colonies.
They were representatives of rump parliaments in 13 colonies.
That's right, and they interposed between the people and the King of Great Britain and Parliament of England. And
What do you think the federal government do? What do you think Obama and Holder,
I have no idea what President Obama would do in anything.
if, I'm going way out on a limb here, but I've been thinking about this. If a state said, we're not doing it, Texas has in the treaty that they had with the U.S. government to come in as a state, they retained the right to withdraw from the union. If Texas or some other state said, we're done. We're done killing our babies. We're done with homosexual marriage. We're done with the tyranny of the federal government and the federal judiciary and the Supreme Court. We're leaving. And we're going to make it a crime again to kill babies, and we're going to protect marriages between a man and a woman.
I don't know what would happen. I mean, it hadn't been done except,
over a bad reason for the slaves,
Yeah.
the state right to own a slave. There was no right to own a human being.
Yeah,
So that was
that's right.
that was a false state right.
That's right.
I'll ask you, would you ethically think that it would be appropriate? Do you think it would be within their right
I
to
think
do it?
that all officials have a right not to obey an unlawful order.
But do they have the right to secede?
Well, secession is something that hasn't been brought up. Thomas Jefferson brought it up back in 1825. As a matter of fact, New England was one of the first states to talk about secession. So, I don't think it's time to secede now. I think it's time to stand up for rights. You're talking about something that people have no ideas about. They won't even stand up for their rights. When they let a majority of one on the court dictate that marriage can be something different than it's ever been, we're not talking about secession. We're talking about just standing up for your rights. We've been deceived in what the Constitution is. We don't understand the Constitution anymore. And if you don't understand the Constitution, how can you understand anything else?
Do you think that this ruling could unravel the republic or unravel our liberties?
I think it's going to destroy the nation.
All right. So therefore, if this has the potential to destroy the nation, then why not get out of the nation? Why not say we're done? We're done. We are not going to be a part of this.
Well, that's just that's something.
I mean, that does follow logically.
Yeah, but I don't think you're going to find anybody that wants to secede.
There's people talking about it in Texas.
Well,
there are people talking about it. And I've never even given it a moment's thought until this decision. This did something to the country, to the fiber of the country. We're not a free people anymore.
Yeah.
I mean, do you think that we're a free people?
We're supposed to be a free people. And if this carries out the way I think it's going to carry out, it's going to be very doubtful because there's going to be serious questions about our religious liberty. And I am quoting, basically, I think, Justice Thomas that said the very thing.
He really focused on that this
He
is
said
a
the
complete
majority
assault on religious
decision
liberty.
threatens the religious liberty of our nation has long sought to protect. Alito said it would be used to vilify those who refuse to
And
assent.
to stamp out all resistance to
stamp
the
out all
new
resistance.
orthodoxy.
Yeah. And Roberts said today's decision creates serious questions about our religious liberty. That's the Chief Justice of the United States. That's not me. That's his words.
Well, a lot of the journalists, one of the reasons that I wanted to do this interview was to let you be heard, not in 12-second sound bites, or not so that some malicious journalist could pull a quote out of context, but to give for you to have a paced atmosphere in which you could lay out the reasoning of why we're in danger, why this is against the law, why it threatens our liberties, and what that means. So, you're a judge. You have a law degree. I'm a business owner. Tell me what's going to happen to me. Tell me what's going to happen to me when I say, I'm not catering this homosexual wedding. And then
quite frankly, I think if you say that, then you're going to be hit with a fine in federal court. They'll go into federal court on you. And I think that's what's the danger of
the Interstate
losing
Commerce
religious
Clause
liberty.
is the way that they did away with the Jim Crow laws. They said, look, if you're open for business, people can come from another state to sit at your lunch counter. You're open for business for everyone, and you can't discriminate. So that's the line of logic that I see them using. And then if I say, I'm not paying the fine, I'm not doing the wedding, and in the fear of God, like the apostle says, whether it's right in the sight of God to obey you or God, I'm obeying a God.
That's already been brought up in other states, and they've been taken in and threatened with loss of their livelihood. In fact, I've got a case right here that.
But is it within a judge's purview to say, Mr. Terry, I don't think you understand the authority of this court. You're going to either pay this fine or you're going to sit in jail until you reconsider. Could it happen?
It could happen, yeah. And listen
do you
to this.
Do you think it could happen, or do you think it will happen?
I think it will happen, yes. I
So
think that,
for the point of stopping and having everyone take a deep breath, do you think that there will be people who go to jail for contempt of court who just say, I'm not doing
well, let
this?
me just read what this lady here in Washington said. And she was offered by the attorney that, Ferguson, I think it was. She said this, she offered to pay a fine of $2,001 and they would dismiss the charge. She said, your offer reveals that you don't really understand me or what this conflict is all about. Stutzman explained, it's about freedom, not money. I certainly don't relish the idea of losing my business, my home, and everything else that your lawsuit threatens to take from my family. But my freedom to honor God and doing what I do best is more important. You chose to attack my faith and pursue this not simply as a matter of law, but to threaten my very means of working, eating, and having a home. If you're serious about clarifying the law, then I urge you to drop your claims against my home, business, and other assets. This kind of thing is going on in our country today, yes.
Well, it's going to exponentially increase with this ruling.
It has that potential.
What would you say to state legislators and state legislatures around the country? Because thank God that the state legislators are usually in the hands of pretty good people right now. Our federal Congress is lost, but there are some really good, godly Christian men and women.
Well, there's some good people out in the legislatures, yeah.
So what
I would
you say
tell
to
the
them?
legislatures to look at the way the Constitution would address this problem. That's under Article 5. Article 5 says there's two ways to amend the Constitution. Amendment to the Constitution will overcome the President of the United States, the legislature of the United States, and the Supreme Court of the United States. If 2/3 of both houses of Congress, the Article 5 is very explicit, saying it can occur by 2/3 of both houses of Congress recommending to the states, which if approved by 3/4.
3/5, isn't it? Is it 3/5 or 3/4? I don't remember. I shouldn't contradict a sitting Supreme
3/4.
Court. That's right, I apologize.
3/4 thereof, then it would become a constitutional amendment. George Mason saw the other problem. What if Congress becomes corrupt and won't pass such a recommendation? Then it says, or on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid as to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states or by 3/4 in conventions thereof, or by conventions in 3/4 thereof, as one of the other mode of ratification.
So there
may
could be a
approved
federal
by Congress.
constitutional convention, and then states should have their own constitutional conventions, or the legislatures of those states could say yes, what they agreed to at the constitutional convention, to have a constitutional amendment that says marriage is between a man and a
It's
woman.
not a constitutional convention, and that's the first fallacy that many people
I
make.
thought it was called that.
No, it's not called that. Read Article 5. They call it that. They call it a constitutional convention. But that's not what the Constitution says was. That implies that they're going to change the Constitution. This is not what that Article 5 says. It says, and you can read it right here. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to the Constitution, or on the application of the legislatures, 2/3 of several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by 3/4 of the several states, or by conventions in 3/4 thereof, as one of the other mode of ratification may be approved by Congress.
Well, I agree with you. It doesn't say that. I think that they're just using it as shorthand.
Well, they're using a shorthand term that implies they're going to change the Constitution, but Article 5 says it shall be valid as to all intents and purposes as part of the Constitution, so it's not changing the Constitution.
Would you support amending the Constitution so that Supreme Court judges were elected and to a term, not these lifetime
I would
appointments?
first rather see that the federal district courts were elected or served terms.
But not the U.S. Supreme Court.
Well, it's because it is the original part of the Constitution. Now, I realize that they can change that.
We can change it.
Yeah, you can change it.
But the Constitution also is who authorizes, or what authorizes the president to appoint federal district judges.
That's right. No, well, Congress is the one that controls whether federal district judges even exist. The only existent court, a federal court, under the Constitution is the United States Supreme Court. All other federal courts and courts of appeal are designed by Congress. They can eliminate them if they wish.
Or they could have
to go back to an understanding
an election.
Yeah, to go back to and understand the Constitution, you got to understand that these courts serve at the pleasure of Congress, and they can they have a lot of power over them.
Speak to Christians who are not in office right now. There's young men and young women who are just so upset, and some of them are saying, "I want to change this." And this is a legal matter. And to quote a very wise person, this is either going to be solved by a gavel or a gun. I mean, something is going to give here. So if they're saying, God forbid we have civil war, God forbid there be violence, I want to get in office so that we can remedy the evils of this country. Speak to them. Speak to their heart.
Well, I think they should. I think that Christians should serve in public office. That's the only way we're going to maintain the country we have. And if this opinion goes into effect, it has an attempt to drive Christians from office. People that issue licenses are not going to want to serve and be under the thumb of a federal judge. And that's the danger of this opinion, because it threatens religious liberty, and people tend to shy away from
drives
Christians out of public office.
So what do you say to those who are pondering it right now? What's a word of encouragement you'd give? You've been in some brawls.
I say God is the author of what happens in our lives, and we're to stand for truth. And standing up for God in law and in government is a noble thing, and God will bless it.
50 years from now, if you and I are not here, which is likely, and someone is rifling through American history because XYZ happened 20 years from now as a result of this case, what do you want to say to those people 50 years from now if somebody digs this interview up?
I'd say the same thing Dred Scott said. The opinion in Dred Scott by Benjamin Curtis. It said that in 1857, and that was a lot more than 50 years ago. 1957 would have been 100 years. He said, when a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, we have no longer a Constitution. We're under a government of individual men who, for the time being, have the power to declare what the Constitution is according to their own views of what they think it ought to mean. And that simply means that if people get in office and start ruling by their own feelings, you have no longer a law like the Constitution to go by. You're under a government of individual men. Now, Dred Scott was overturned, as you said earlier, Justice Roberts said earlier, on the battlefields of the Civil War and by constitutional amendment. And this amendment, this ruling by the Supreme Court is as pernicious as that was ever thought to be. I think it's a perilous time for our country.
I do too. I think we're in danger. I appreciate you giving us so much time. And is there anything else that you want to say to the people? Anything that's on your heart that you want to say to the people that are watching it in closing?
Well, this is probably the only country ever established on the laws of nature and nature's God. And people don't understand what that means. They think it means that it's frivolous words or something. Those were legal terms under John Locke and William Blackstone. The laws of nature and nature's God. Not only were we able to declare our independence because of the laws of nature and nature's God, but James Madison, the chief architect of the Constitution, said that we were entitled to have a Constitution because of the laws of nature and nature's God. I think he said that in Federalist 43. And those had a very specific meaning. That means that God's law is a higher law. And we historically, the chief architect of the Constitution recognized it. Thomas Jefferson, who wrote the Declaration of Independence, recognized it. And we should recognize, too, that the Declaration, for example, which recognized that God gives rights and government's role is to secure those rights for us, is law. Now, many lawyers and judges, oh, I made a mistake. That's not law. Well, if you go to the United States Code and you look up organic laws, you'll find the Constitution of the United States. And you'll find before that the Declaration of Independence. It is part of our organic law. And I don't care who wants to cross me on that. You can go to the United States Code and turn to the page and find it. And so we should regard these things more seriously, because if God gives rights and government's role is to secure those rights, when government dismisses God out of the equation and pretends to get rights, we suffer accordingly. And that's what we're facing in our country, whether it be with abortion, same-sex marriage, or anything else. If government pretends to give rights, it'll always take one away.
Well, you referenced, and forgive me for this addendum, but you referenced the phrase in the Declaration that says that governments exist to protect the rights that
secure
are God-given.
the rights God gave us.
Right. And when a government becomes injurious or becomes a threat to those rights, it is the right of the people to alter or to abolish.
And to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness.
Are we headed there?
Well, I think that's where we were in 1776.
Are we
and if
there
government
now?
is not securing the rights God gave us, which obviously when you take marriage and it's an institution ordained of God, they're taking it and redefining it, that's not really securing it, is it?
No. So is it our duty to alter, to abolish? That's the issue. It's frightening.
Prudence indeed will dictate the government's long established should not be changed for light and transient causes, and accordingly our experience has shown that mankind are more disposed to suffer while evils are sufferable than the right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such governments to provide new guards for their future security. Such has been the patient sufferance of these colonies, and such is now the necessity which constrained them to alter their former systems of government. The history of the present King of Great Britain is a history of repeated injuries and usurpation, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world.
If we were to take out the King of Britain and
If you
insert the
place the
Supreme
United
Court
States
there,
Supreme Court, it seems fitting, doesn't it?
it does.
Okay.
Long life to you.
Well, thank you, sir.